Wonderful. Okay, amazing. Hello, everyone. Thank you for joining us. I'm so glad you're here. We have a couple people joining, and I'm sure a couple more will filter in, but I'm going to go ahead and get us started as it is time. Thank you for joining. My name is Andrea Scarpa May. I'm the Programs and Events Manager here at the Yountville Chamber of Commerce. I'm thrilled to introduce our speaker, Angela Nelson from DP&F Employment Law Team. She is an employment law professional, and she's going to be telling us a lot about the updates and things that you will need to know as a business owner and manager um, for your employment. If you have any questions during the presentation, you can go ahead and put them in the chat. We'll also have time at the end for questions. Um, Angela Nelson is an attorney, like we said. She is experienced with the state and federal legislation, advising commercial and municipal clients on liability matters. She is a professional, so listen to her. She knows what she's talking about. All right, I'm gonna let her take it away.
Right. Thank you very much. And good morning. Um, so this will just be a presentation of some of the new laws that were added in 2025 to be applied 2026 and moving forward. So this year was not a heavy year for employment law. I think last year was a lot heavier. But this year we only had a few nuanced changes, but they are important nuances to pay attention to. So we'll just go through each of them, and we've actually been getting quite a few questions about them. But as we move to some of the questions, I want to let you know that this is not as intended as legal advice. We're only providing a general overview. If you have specific questions about a case that you are dealing with or about a contract that you have specifically, please consult your attorney if they happen to be us or whoever they may be. But it's certainly something that if you have a question about, ask, because you want to make sure that you are in compliance. So for the new laws for 2026, a couple of things before we get into the individual laws that I'd like you to pay attention to. They do not all start at the same time. So the implementation dates vary. Some became law and were active as of January 1st. I don't think we have any that started last year, but I could be wrong if I'm misremembering. Some don't start until 2027, 2028. So you do have some lead time on some of these, and for some of them, you may be playing catch up if you're not already in compliance. So just pay attention to the start date. And the other thing to pay attention to is the potential penalty for failure to comply, because some of them have surprisingly steep penalties associated with them, despite the fact that they seem to be somewhat small changes or requirements. Okay, so the first one that we will cover is the stay or pay provision. So at present contract, this one's that's already been implemented as of January 1st of this year. So any contracts that were entered into as of this year cannot require a stay or pay provision in them. So these are provisions requiring employees to pay back certain upfront costs that employers take on, such as visa fees, training fees, relocation fees, credentialing. So anything that the employer had to pay in order for the employee to come on board or to stay on board, employers can no longer require that employees pay that back as a condition of their employment. There are two very specific carve-outs for this. One is for tuition reimbursement, and the other one is for a sign-on or retention bonus. We've received a lot of questions about these particular carve-outs. So if you have a situation where you think it might fall into one of the two exceptions, I would suggest you consult your attorney, because they are very specific, and I can go through the factors, but it's really conditioned on the circumstances that you have. So just briefly to go over the factors, because we do receive a lot of questions on this one. For the tuition reimbursement program, there are 5 factors that would let it fall into the exception. The tuition reimbursement agreement would have to be separated, a separate agreement from the employment agreement. The credential cannot be a condition of employment. So if you're, requiring them to maintain a credential in order to keep their employment, that can't be something they have to pay back. The cost cannot exceed the cost to the employer, so you can't charge any interest. Repayment has to be prorated and it cannot be accelerated. And finally, if the employee is ultimately terminated, they cannot be forced to pay unless they were terminated for misconduct. So again, these are, as you can tell, very, very specific, and the the legislation is really intended to limit what employers can do to prevent employees from moving from one employer to another. So they shouldn't feel beholden by a loan, essentially, from the employer. And for the sign-on bonus, it's very similar. It has to be a separate agreement from the employment agreement. It has to be the employee has to be notified that they can have to consult an attorney, and they have time to do that. It's 5 days. Um, there's no interest that could be charged, and the repayment must be prorated again. And the worker can defer taking the bonus until the end of the retention period so that they can avoid repayment requirements. And again, like with the tuition reimbursement, they only have to repay if they choose to leave or if they're terminated for misconduct. So again, if you have specific questions about that, just talk to your attorney. It's a very narrow carve out. And oh, one more thing on that one, since we were talking about penalties. The penalties would be actual losses or attorney's fees. And you know, the attorney's fees is where you are usually paying a lot. So make sure that you're in compliance with that when it's already in effect. So if you have anything that, any agreements currently that you think might fall under this provision, if it's historical, something that an employee was already paying on a contract from prior to 2026, you may not have to worry so much about this, but you probably want to consult counsel just in case, particularly if there's anything else that the employee has signed since starting their employment. Okay, moving on. This is for paid family leave, and this is to come into compliance with some federal laws. So this one doesn't come into effect until mid 2028, this change. So again, they all have different start dates, and this one you have time to update your handbooks and to update any HR personnel on this policy change. It's not a substantial policy change from the perspective of employers. This does not change the amount of leave that an employee is entitled to. It simply changes the people that someone can take PFL leave for. So PFL leave, as you probably are aware, is taken typically for two reasons: for new mothers, for baby bonding, and also for caring for a sick relative, typically. Now, under this new law, the sick person that you can care for does not have to be a relative. It can be someone that the employee designates as the equivalent of a family relationship. So this isn't something that the employee has to designate up front with the employer. They designate it at the time of filing the claim. So there's nothing that needs to be done initially from the employer's perspective. However, an employer can limit the number of designated persons that an employee designates per year to one per year. So just be aware that if you do come across one of these and you see someone who's, designating different people over the course of a year, you can put a limit on that. But again, it doesn't extend the amount of leave. It's 8 weeks and that's it. There's no, it's 8 weeks of wage replacement and 12 weeks overall for the 12-month period. I think I said 12 weeks, not 12 months, but just in case, 12 weeks for a 12-month period. Medical certification is required just like it is currently. So if there's any concern about fraud or abuse, that's something that when they file the claim with EDD, they will have to provide medical certification that this individual, whomever they may be, does have an illness that would fall under the PFL requirements. So again, from the employer's perspective, this is probably a handbook update, maybe a notice to employees, maybe a policy if you want to limit the number of designated people, but it's not going to be a significant change operationally. But penalties for failure to comply are $500 per employee per day. So it can run up if you have a large number of employees. So just be careful. All right, moving on. This one is a notice requirement. So it's a Workplace Know Your Rights Act. This one went into effect as of 1st of February. Why not the 1st of January? Probably because the labor commissioner could not get the sample notices out in time. So they do now have sample notices out I have all the languages listed here. It was just English and Spanish, but now they've added Chinese, Vietnamese, Korean, Tagalog, Hindi, Punjabi, Arabic, Urdu. But these are standing requirements that need to be posted in the workplace. And they include a number of provisions regarding immigration, which is a hot topic, as you are well aware, law enforcement actions at the workplace, certain workers' rights. Now, the important right that was included in this packet of provisions that an employee is now required to have notice of is an employee has to be offered. Where is this? Did I put it in the slides? Well, an employee has to be notified of all of these rights. And I think I had a list of what here we are. So it's workers' compensation benefits, including disability pay and medical care for work-related injuries, immigration inspection notices and protections against unfair immigration-related practices for union organization, and also constitutional rights. And there's also a requirement that certain enforcement agencies that are responsible be included with their contact information. So these notices are available from they're available online at the Labor Commissioner's website, so you can get a copy of them there and just post them. And if you have any questions, there is also some information available on the Labor Commissioner's website about them, if you need another language, for example. All right, moving on. The pay scale requirement for job postings. This one changes or tweaks an existing law, and it is important for when you're posting jobs with a pay range, because as you are probably aware, there are some pay ranges that are wildly diverse. So you might have a pay range that starts at 50,000 and ends at 100,000, and obviously depending on experience or other factors. But the important clarification for this law is that now pay scales must be posted with a good faith estimate of the salary or hourly range that the employer can reasonably expect to pay for the position upon hire. So you cannot include in your range something that someone could potentially make if they were promoted, or if they were someone who was going a step up, if you have a step program. So you need to make sure that you start at the bottom pay range. Now, it can be bottom pay range for someone who potentially has all of the qualifications that you're seeking, and the range obviously can still be a range, but just make sure that it is something you can justify if questioned upon. Okay, and moving on. This is the same act, but a slightly different portion of it. The Equal Pay Act, it now prohibits employers from paying employees at a wage that's less than those of others. And this was already in existence, but the change is about what is considered a wage. So again, Equal Pay Act has already been in existence, but wage rates has changed now to include not just a salary, not just a bonus, but any form of pay. This includes any overtime, any stock options, any vacation that the employee has the opportunity to take advantage of, reimbursements, any kinds of insurance plan, life insurance plan, cleaning, hotel accommodations, what have you. So if you have individuals who are at the same employment level, at the same job title, and one of them is taking advantage of a lot of travel, and the other one is not for personal reasons, just be sure that you can justify that because those changes in wages, and because those extra perks are now considered wages under this law, they can be considered if a lawsuit is brought from the individual not taking advantage of those things. So just make sure that it is still fair for employers to pay different employees differently depending on the needs of their employment or what they're going to take advantage of. But you just have to have a fair justification. You can't simply offer one employee all of the perks and one employee none of the perks. So if you have specific questions about that, again, consult an attorney because the penalties for this kind of violation can be pretty steep. It's $750 per penalty. So that's it per violation, plus attorney's fees. So make sure that you are in compliance.
Hey, Angela, if there's
Yes.
anyone in the waiting room, could you let them in since you're the host?
Sure.
Thank you. Oh, perfect.
Ah, all right. Do we have everyone? I think
I think
so.
so.
Okay. All right. Moving right along. And if you've just joined us, I apologize. I think you may have been stuck in the waiting room. Um, and welcome. We are just going through some of the new laws for 2026 and moving forward. So currently we are on the employee personnel records requirement. Now, this is a change that we've actually had a lot of questions about. This requires employers to maintain education and training records as part of its personnel records for an employee's performance. So this would need to include specific information, the employee's name, training provider's name, the duration and date of the training, core competencies. They're listed here, so I don't need to repeat them all, but this is something that the employer must maintain for 3 years. And just as with the personnel record, if the employee requests it in writing, the employer must provide it within 30 calendar days. The employee can only request it once a year. So, for privacy reasons, if a former employee requests their training records, an employer can ask them a number of questions to verify their identity, but they must provide these records. And failure to comply will result in a penalty plus attorney's fees. I think it's a $750 penalty. Let's see, any questions? I don't know if I'm seeing the questions or not, if there are any. Don't think there have been any yet. Okay. Moving right along. This is another data reporting requirement that does not go into effect yet, but will be coming down the pipeline. So beginning in May of 2027, this is the 2026 reporting cycle for the CRD. Employers, and this is only for employers with 100 or more employees and who are already the employers who are reporting to CRD, for they're including various demographic information in the reporting requirements, and employers will also be required to classify employees according to 23 job categories, as this follows a federal standard occupational classification system. It formerly or currently is 10 job categories. So you have time, make sure that you go through the employees and look through the new job categories that are posted under the SOC, and before May of 2027, your reporting is required. Ensure that you are putting the employees in the correct categories, because if you simply use the same 10 categories that you were using previously, it will probably flag a violation. And unfortunately, this change also has come with a mandated penalty. So previously, the penalty was optional for the CRD. Now, CRD will be required to enact a civil penalty of $100 per employee for the first failure or the first violation, and it's $200 per employee afterwards. So you can imagine if you have 100 more employees, this can add up quickly. So make sure that you are in compliance by May of 2027. There is time. All right. Now this is a change in the law that isn't specifically employment related. However, there are particular implications for employers that employers should be aware of and pay attention to. So, following a number of other laws that open up a look back window for sexual assault or sexual harassment, there's already been a change in the law statute that provided this look back period for municipal um, well, for municipalities. Now, this one is simply for it's for employers, it's for anyone in the private arena. So there's a 2-year look back window that started in January 1st and ends at December 31st of 2027. So it's 2026 to 2028. So individuals who otherwise would have had time barred claims to file lawsuits against their perpetrators for sexual assault or harassment, but also against any institutions that engaged in the cover up of sexual abuse. Now, you can imagine that if you're seeking recourse from a prior perpetrator, a civil recourse, um, it, individual perpetrators are unlikely to have deep pockets. So many times, plaintiffs' attorneys in this arena are looking for the institutions that engaged in the cover up. And that is what they've done with the municipalities. And there have been some astronomical settlements going on, especially if you look at, for example, Los Angeles, to resolve these institutional cover up allegations. So, in this case, employers may be the institutions that allegedly engaged in the cover up of sexual abuse. So, you can expect to see, because there is already an existing plaintiff's bar that handles these kinds of cases, you can expect to see that there may be some employers, especially larger employers, who may find themselves on the other side of some of these old sexual harassment, sexual assault claims. So be aware. You may want to, if you know of something like that, you may want to flag it for your HR department. Make sure you're maintaining your records if you are coming up on a retention policy that's going to destroy any records that you think you might need, because this is only for the next 2 years, but you might want to be on your P's and Q's as far as maintaining records that you have from prior situations, because it could come back up in the next 2 years, even if it's older. And the important thing for employers to pay attention to is claims of sexual harassment are not subject to arbitration. So if you have an arbitration agreement with your employees, the sexual harassment claims will nullify any claims that are brought along with the arbitration claims. So, for example, if an an employee brings a claim for sexual harassment along with a wage claim, the wage claim would normally fall under the arbitration agreement. But because it's being brought along with the sexual harassment claim, it will no longer fall under the arbitration agreement. So it is an exemption that you should be aware of, because it may come up more frequently in the next couple of years. All right. So this next one is comparatively feels a little bit less important, but it's very frequent that these vehicle expenses come up. So this clarification doesn't change the law per se. It just clarifies some of the vehicle expense issues, because it is something that comes up frequently. So um, it clarifies that employees who drive a vehicle, or simply driving a vehicle, a personal vehicle for business, does not support the position that that individual is an independent contractor as opposed to an employee. Also, an employer, of course, must indemnify an employee. So again, employee, for reasonable business expenses. That includes any of the gas and travel, the insurance, anything that's used for the discharge of their duties. So they can do this a couple of ways. They can do a flat fee, or they can do standard reimbursement rate. Standard reimbursement rate here for 2026. I, well, I did. I was 72.5 cents to the mile. So you can use that, and that might be what you choose to use unless you want to use the flat rate. But the standard mileage is what a lot of employers use. And the flat rate can be used as long as it doesn't amount to less than the actual cost to the employee. So if you have any questions about that, that is something you can ask your attorney. But remember, it's only for necessary expenditures. So if there's something the employee is doing that's ancillary to their employment, that's not something that would need to be reimbursed. All right, tip theft penalties. So tip theft was a big topic, I think last year or the year before, a while ago, but this is one of the changes to law that came out of it. So employers, as you know, managers aren't allowed to partake in tip pools. So managers aren't considered employees under the tip theft law. But so tips or gratuities are the sole property of the employees. This law closes a loophole. The labor commissioner previously wasn't allowed to issue penalties or citations for the violation of tip theft. This law corrects that. Again, it's not a significant change for a lot of employers, but what it means is that the labor commissioner can now include tip theft in any penalties or citations. So we may start to see more of these claims for INPAGA actions where there are tips available. So just be aware, it's a nuance, but it can potentially be a large amount to be included in a lawsuit if it moves forward that way. Okay. All right. We've reached the end of the new employment laws per se, but I wanted to give a brief, not overview, but just touch on a couple of things with AI because it is a hot topic right now. And there are a number of questions that have come up about it. And I think we will probably provide a more in-depth presentation specifically about AI. Now, last year there was a no robo bosses law that the California legislature attempted to pass. It was passed by the legislature. It was vetoed by the governor. It has just been reintroduced as of the 1st of February of this year. So this is brand new coming about. And now there are some changes to the way that the law is written to accommodate some of the concerns that were raised by the governor. And I just wanted to highlight some of these for you because the purpose of this law was to remove or limit automated decision-making systems in the employment law arena. So these are for hiring purposes, for monitoring purposes, for termination purposes, the whole gamut. And Governor Newsom was concerned about some of the requirements being too burdensome for employers. So one of the provisions that was included in the previous law that has been removed was the requirement to provide advance notice to workers before using the AI systems for employment decisions. Now there is still a notice requirement, but it's retroactive. So employers must notify employees if there has been a significant employment decision, or not a significant, an employment decision using AI systems, but it can be after the fact. And this is particularly if it's assisted in discharge or discipline. Now, again, this is just something that's been proposed. It's not the current law. I want to make that very clear. But this is something that employers should be aware of because if, apologize, it, if employers are already using AI systems to make certain decisions like discharge or discipline decisions, these are laws that may impact you moving forward. Additionally, there is a new prohibition that was added to using any AI systems or automated decision systems that attempt to predict employees' future behavior. So this would ban any predictive analytics, so forecasting workers' performance or turnover risk or the likelihood of misconduct. I don't know if anyone's using anything like this. It is something that is pretty um, advanced for AI to be performing. But some tool packages, if you have a package that you've purchased through a provider, may include some of these functions. So just if you are using a package of AI tools, make sure that that is something you are aware of, what tools are provided, because if this does go into law, those are some tools you will not be able to use anymore. And the providers aren't going to be the ones to pull them. You will probably have to be the ones to pull them. So some things that are maintained from the prior bill are the requirements that a natural person, so a human being, has to make the final decision on firing or disciplining workers, and employers cannot delegate that decision to the AI. Furthermore, contract language um, establishing that so AI cannot be the sole basis for the discharge or disciplinary decisions. You can't have AI simply scrolling through someone's performance or their online login information and using that to terminate employment, for example. And that's probably something that larger employers are more likely to be guilty of. But just make sure you're paying attention to what AI tools you are using again and who is making the final decision. So another piece of legislation that has just been introduced along with the change to the No Robo Bosses law is a change that would be sort of an AI version of the WARN Act, the Workers Adjustment and Retraining Notification. So for layoffs, if you're doing a mass layoff, um, that's AI driven. There are going to be different requirements under this law than there are for the typical WARN Act requirement. Again, this is not existing law. This is something that is potentially coming down the pipeline. So just be aware if you're using AI to help you determine layoffs or to um, help assess workers' performance in the determinations of who's going to be terminated in a mass layoff, this is something you may want to pay attention to. It will potentially require a longer notice period. Um, there are it's a lower threshold, so lower number of workers would trigger the requirement. And there are a couple of other provisions. There's state reporting requirements. There's more coverage. So it wouldn't just apply to 100 employers with over 100 employees. It would apply to employers with 75 or more employees. So just be aware these are things that are percolating right now. They probably would be on our update next year if they were passed. They may still need to go through another round of tweaking before they become law, but we'll see. These are things that are certainly brewing. And AI is a hot topic right now in many arenas, but certainly something that employers need to be paying attention to as it becomes a more readily available tool. The regulations are coming after the fact, so the AI providers are creating a lot of content available for employers and beyond. And the regulations are coming on the heels of these developments. So you may already be using certain things, but just because they are available to you doesn't necessarily mean that they will comply with law as it changes. So just be on the lookout for any changes. And usually we have quite a few questions, but we have not received any questions. So I have reached the end. And if you have any questions, please let me know.
I don't really have a question, but I thought the AI boss decision making was very interesting.
Yes, it's definitely there are a lot of interesting AI aspects that are moving forward. And like I said, I think we'll probably do a deep dive into them. And it's part of a separate presentation, which I'd be happy to have everyone join when we do that. Um, it's a very fluid environment right now, as you can imagine, and it's coming up in ways that people didn't even really consider. For example, we've seen it arise with employers who utilize camera functions inside vehicles for their drivers, for example, and they might have an AI tool that registers whether or not there's movement on the camera. And if there's no movement on the camera for a certain period of time, then perhaps it flags that person for performance review or for a check because maybe they're not in the vehicle as much as they ought to be, or during the periods of times that they ought to be. So it's coming up in ways, like I said, that you wouldn't necessarily expect, but it's prevalent in the industry. It's prevalent everywhere, and it's coming up unregulated. And there are a number of lawsuits regarding the use of AI, and that will probably change the landscape as well. But right now, it's still so new that we don't really have any specific guidance on everything collectively and comprehensively. So we can put together recommendations on certain, AI protocols, but it could change. It could change tomorrow. It is changing today. And as I showed you, those are just bills that were introduced this month. So this is a very active area of the law. But are there any questions or anyone who joined later who maybe wants me to go back and look through some of the statutes that we discussed earlier? I'm looking at the chat. If there's anything in the chat, you can put it in there.
It looks like you covered it very well. No one is
I guess
asking
not.
any questions.
Okay, well, if there are no questions, I guess I can give you back a little bit of your time. Oh, there's one question.
Thank you,
Oh, just
Tracy.
okay. Thank you. Thank you very much. Yeah, if you do think of something afterwards, my contact information is there. So please just go ahead and send me a message or, contact your attorney if it's something that you need to contact them about.
Wonderful. Well, we'll give you all a little bit more time in your day back. Thank you so much, Angela.
Absolutely. Anytime. Thank you very much.